A power of attorney is a legal instrument which is created for the purpose of conferring authority on an agent to perform certain acts or functions on behalf of an individual or other legal entity. Persons who are away from the jurisdiction on a long-term basis or whose movements may be limited as a result of ill health, incarceration, or a simple lack of availability will find the powers of attorney useful. This instrument can be used for a wide variety of purposes, from conducting financial transactions to acquiring assets on behalf of the donor. For businesses, a power of attorney would allow a representative to carry out certain functions on behalf of the company, such as opening bank accounts or signing contracts. So long as you are 18 years of age and mentally competent, a donor may appoint one or more agents to handle his affairs, either jointly, severally, or a combination thereof. And under the circumstances, the powers of attorney can be tailored under broad general terms or may be particularized to address specific circumstances to be executed by the agent in any manner the donor sees fit. After all, the very purpose of the power of attorney is to ensure that your affairs are carried out while you are alive, which means then that the instrument will remain valid for the remaining life of the donor and will become null and void if the power of attorney is revoked by the donor himself, or if the agent himself dies or otherwise is rendered unable to act as the attorney. Now, there are other circumstances where powers of attorney can be rendered invalid, which comes to our next point in this discussion, which concerns the distinction between the two types of powers of attorney recognized here in the Bahamas. The first of which we will refer to as the standard power of attorney, and the second being an enduring power of attorney. The difference between the two concerns the validity of the power of attorney beyond the mental capacity of the donor, to which the standard power of attorney will come to an end soon as the donor is declared mentally incompetent. Under the provisions of an enduring power of attorney, however, the validity of the instrument remains beyond the mental capacity of the donor, making the enduring power of attorney a much desired document in circumstances where a donor faces life-changing circumstances, such as an oncoming illness which may lead to temporary or permanent mental impairment, or where a medical procedure may place the donor in a comatose state. It is important to note that the provisions of the enduring power of attorney can only apply to decisions as it relates to asset management and cannot be used to govern decisions pertaining to the physical care of the donor himself. Powers of attorney in the Bahamas are governed by a combination of common law principles and statutory law, as found in the Powers of Attorney Act and the Powers of Attorney Rules, which sets the conditions required for both standard and enduring powers of attorney, which calls for the donor to be of sound mind and at least 18 years of age at the time that the power of attorney is granted, and also addresses the need for witnesses at the time the instrument is executed. At this point, it is strongly advised that you retain the services of a local attorney who should be able to advise on the right type of power of attorney required under the circumstances and to properly construct the instrument to the proper legal standard, as the requirements for both standard and enduring powers of attorney are completely different, and you may jeopardize your efforts if attempting to construct a power of attorney of your own. Now, should you have any further questions on this topic, please feel free to visit our website at www.loyalx.com. You can also subscribe to our YouTube channel to watch our daily presentations, or join us on our Facebook or Instagram pages for regular updates. Thank you for watching.